Hello everyone, this is LB290, CSP tutorial video here. I'm going to be conducting this in English. I'm not quite sure whether you should do it in Thai or in English, but I'm just gonna go with the default of our faculty here then. So I'm going to be guiding you guys through two questions, right? Questions 1 and questions 2. Let's start, alright? So the first question, we're just going to read it first, which is the geographical impact of climate change on statehood is rather clear. Ever since scientists have been warning about climate change and the rise in sea levels it would involve, several small island nations have been at the center of a discussion involving in situ adaptation, possible cross border migration, and statehood. Indeed, the future of states such as Tuvalu, Kiribati, or the Maldives poses a challenge to the traditional concept of states in that to maintain their existence as states, their formal need for a territory and population might need to be relaxed, if this is possible at all. This new problem has generated an active scholar discussion, bolstered by the unprecedented nature of such a situation. Discuss the above quote in light of the criteria of statehood under the Montevideo Convention on the Rights and Duties of 1933. All right, so we're going to be first examining the prompt of what it wants us to do. So you'll notice that the question doesn't ask us to answer whether they are states, but it asks us to discuss, which is a lot more broad. So I'm going to use my liberty and freedom here to answer it in almost every possible way so that you can cover pretty much every topic, and if you have time, write them down, right? So what does this prompt want us to do? It wants us to discuss the quote in light of the criteria of statehood under the Montevideo Conventions on the Rights and Duties of States in 1933. So the first thing that you would I think would be very good to do is to examine the Montevideo Convention. Right. So in examining the Montevideo Convention on the Rights and Duties of States, you need to first, identify what it is. So in this case, it is quite obvious that the Montevideo Convention is a treaty. And now, why should we care about a treaty? Is because a treaty is one of the sources of public international law. And this is where you should explain to the professor what are the three main source and one subsidiary means to interpret the law, right? So the the sources of international law, according to Article 38, subsection 1 of the ICJ statute, is that firstly, it is treaty. Second, it is customary international law, GPL, general principles of law. And finally, as a subsidiary means of interpretation, judicial decisions, and teachings of the most highly qualified publicists, right? Okay, so in explaining this, you need to elaborate on what all of them mean, right? So what is a treaty? What is CAL? What is GPL? What is subsidiary means of interpretation? You don't have to do it too much. I think the treaty question will be a lot more important in the second case. But firstly, we have to examine what the Montevideo Convention on the Rights and Duties of States are. So you notice here that I wrote two. One, treaty. The second one is customary international law, although this one is debatable, right? Ajahn Jia has said in class that generally the Montevideo Convention on the Rights and Duties of State is accepted as a customary international law when it comes to the creation of states, although that is also debatable. But in light of the current situations, it is, again, like, there needs to be a question of whether the Montevideo Conventions will still apply today, seeing as you need to explain to the professor that the CAL is two elements, right? General practice and accepted as law. Right, so this is where we examine what are these two things, right? What are the treaties? Article 2, subsection 1A. If you want to show off, of course, but only if you have time. All right. So once you answer all these questions on what is the Montevideo Conventions on the Rights of Duties, spoiler alert, you can answer these two. It is not a general principle of law, nor is it a subsidiary means of interpretation. CIL, again, debatable, but I would include it here. I guess you could also include it, but also write like debatable because, again, it is debatable. So that is the first issue solved, right? Examining the Montevideo Convention. Now we're going to be looking at the second issue, which is the criteria of statehood under the Montevideo Convention and the rights of duties of state. So what are the criteria of statehoods? Well, you can find that. Sorry, what are the criteria for statehood under the Montevideo Convention? This one you can find in Article 1 of the Montevideo Convention. It's quite simple, actually. So in Article 1, it is very simple. It clearly states that the state, as a person of international law, the state basically equals four things, right? Firstly, a permanent population, defined territory, government, or in this case, effective government, which would be a lot better to include, and finally, the capacity to enter into relations with other states. Now, this is only under the Montevideo Convention, which is in line with the prompt, right? But if you want to show off your skills, which depends, I guess, most highly qualified publicist. It depends. You can also add in the recognition theory, but I wouldn't recommend it since there is no time. What is more important in this case is for you to examine, firstly, what are these four criteria? Because it tells the professor if you know what you are saying or not. So in the permanent population case, essentially what this tells you is that the area of which you govern has a population, has a place for people to stay and all of that, right? You need to examine, right, what is a permanent population, what is not a permanent population. So you'll need to say like, okay, is there a minimum requirement on a number of population? Again, no precise number on this, but can't be too small. It can be scattered or on migration, right? So you'll need to explain that to professor. Second, defined territory. Defined territory is going to be the focus of our question here, but I will explain to you later, specifically in line with the quote, right? So in the defined territory case, you can say something along the lines of like, there is no definition given in the Montevideo Convention, but there are some pointers. Like, for example, the size of the territory is not relevant. And you can give some example like Singapore and all of that, right? Or nor must it be precise. You can give it to Thailand, Cambodia. Or it could also be split, such as the US. Right, so this is the defined territory. And then you move on to explain the government. You basically have to say that what is important here is it's not about whether there is a government or that anyone claims to be a government. It's whether you have control. So the key term here is control. Now, how is that the case? Was it mean effective control? No, because a lot of countries have laws that are enforceable but are not. So I can give you some examples, right? Like the Prohibition era in the United States. It is an enforceable law, but people do not enforce it. Does that make the government not effective? No, because they still have the power to effectively control the state, right? So that's what the government means. And finally, the capacity to enter relations with other states. You can try to link this with the recognition of other states, but what is more important is the capacity to enter into relations, which is basically, can you stand on your own, right? Are you dependent on other states? Are you able to contact other states and all that? see the UN, for example. That could be a good criteria. So once you have explained all of this criteria for statehood under the Montevideo Convention, we can finally move on to actually discuss the quotes in this context, right? So let's look at it. The geographical impact of climate change on statehood is rather clear. So we can see some focuses, right? Climate change, statehood, right? Scientists have been warning about climate change, rising sea levels it would involve. So the key term here is rising sea levels in small island nations, right? In situ adaptation, possible cross-border migration, that's irrelevant, but the key term here is statehood. Indeed, the future of states such as Tuvalu, Kiribati, or Maldives poses a challenge to the traditional concept of states in that to maintain their existence as a state, the formal need for a territory and population, formal, might need to be relaxed if this is possible at all. The new problem has generated an active scholar discussion, bolstered by an unprecedented nature of such a situation. So over here, I have gone on to highlight the important phrases that you should focus on, right? So since this is a discussion question, there are 4 ways for you to be able to answer this. So there are ways to answer. It's not 4, sorry. Firstly, you need to debate with yourself about this term, traditional concept, existence as states. Formal need for territory and population might need to be relaxed. So what I would recommend you first to do here is to first apply your rules to the sinking island states. And you can explain that, if the countries sink or whatever, they would lose 2 criteria, which is a permanent population and territory, and therefore they would lose their statehood. And you can really go be a lot more liberal with this than me. Essentially, after you explained about the traditional concept of statehood, you can go different routes. So the first route is to question the traditional concept itself, right? To say whether we should accept the Montevideo Convention as a customary international law. Like I said, it comes back to the term debatable. Most of the time, most states agree that in order for there to be a state, there must be the 4 criterias, right? However, the continuance to maintain their existence is a lot more debatable because in light of the new situations, it is possible to argue that it is no longer a CIL, as you can probably explain that, it's not generally practiced anymore because a general practice must be uniform, right? So that could be one thing that you can try to argue. Secondly, you can also try to interpret the criteria of statehood a lot more liberally. So this is where you can talk about the territory and population might need to be relaxed, right? So this is where you question this statement, whether the territory and population should be relaxed. And if it is relaxed, how can you identify such things? Because under a strict interpretation of territory, we can look to specifically on the island states. We need to look to unclause. Unclause for some pointers, right? And in this case, unclause offers 2 principles. Territory, and that the island must be able to sustain economic life, essentially. So you'll need to explain that. Right? For the unclause. So you can be a lot more liberal about this. You can be strict and just say like in your there needs to be a strict interpretation of the Montevideo Convention. In this case, it would mean, Tuvalu, Kiribati, and Maldives are gone. They're gone, they're sunken in the ocean, rest in peace, right? Or you can be a lot more liberal and you can say like, oh no, we can try to rectify this situation by changing the thing. It is it's a policy question. It's not really a legal question. The legal questions are all answered with the principles that we have laid down here. Or like I said, you can explain that, oh, it is not a customary international law at all, therefore it should not be followed, therefore they can come up with other rules, right? But at the end of the day, it is your choice. One answer that a previous student has given is more strict. Essentially, he argued that these three island nations will lose their statehood because the criteria are not met. But this is where you can try to fight it, okay? So that is it for question 1. Now let's move on to question 2, which is explain errors which can cause a treaty to be invalid. Illustrate your answer by referring to the Temple of Pravihan case, Cambodia versus Thailand. So in this case, you need to know the history of Pravihan case. And the thing that is really important here is the term treaty, Pravihan. So you need to, of course, make an analysis of the main treaty that is debated in the Temple of Pravihan case, which in this case is the Annex 1 map, right? The Annex 1 map of the 1904 agreement. And you'll need to explain the historical background, which is watershed principle. And then, the focus is on that. So you already know the focus, right? But in answering the question, we need to be a lot more structured. So what I would recommend to do first is issue. This is a more traditional IRAC question. Explaining the issue, which is what are the errors which can cause a treaty to be invalid? And then you go on to the rules. The rules here are pretty simple. It is VCLT. So first off, you need to define what is a treaty, which is going to be in Article 2, subsection 1A, right? And then you'll need to talk about what can cause a treaty to be invalid. Even though it's not really the main focuses of our class in the invalidation case, there needs to be a reference to some articles, right? So for example, Article 48 of the VCLT, or some other articles which are related to that as well, such as Article 79, right? Like I said, this is not really taught in class. This is last year's This is last year's exam. So it's gonna be, I have a feeling it's gonna be a little bit more different, but the main focus that you should focus here is on what is a treaty, right? And this is where we go back to our first question, if you guys didn't follow, right? So we're gonna have to go back and determine what is a treaty. And a treaty under Article 2, subsection 1A, Article 2, subsection 1A has clearly stated that a treaty means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or in more related instruments and whatever its particular designation. And then you'll need to explain the four components of that four elements of that article, which is international agreement concluded between states. So you'll first have to make an analysis. What is an international agreement? And then you'll need to answer what is states. So let me give you a quick answer. International agreement is basically about consent. The two countries come together in order to create a binding legal obligation. So this is the key term, binding legal obligation. And then for the states, you can say that in practice, it really means states, IO, international organizations, special entities, such as the Vatican City. And finally, liberation movements, although this is debatable. The key term here is that you should tell the professor what it is, right? Because as the professor said in class, the professor, when they're checking the exam, assume that the professor does not know anything, all right? So that is not the professor, sorry, the examiner, right? And then the second criteria is in written form. This one is quite self-explanatory. So, must be written, basically, must be written down. And again, it's expressed by the consent. 3, governed under international law, which is basically governed under the general principle of law or the customary international law, where you can make a reference to the VCLT again as a codification of customary international law, right? And then finally, it's whatever, whether embodied in a single instrument or in 2 or more instruments, whatever its particular designation. So what we got from this is, it does not matter if it is in many files or forms, right? Or whatever its particular designation. Right. So in this case, you'll need to focus on the errors. Now we're going to be moving on to the errors. So some of the errors that you can pick and choose, again, is something like Articles 48, which states that a state may invoke an error in a treaty as invalidating its consent to be bound by the treaty if the error relates to a fact or the statement which was assumed by the state to exist at the time when the treaty was concluded and formed an essential basis of its consent to be bound by a treaty. So this is something along the lines of like voidability, essentially, if we're going to bring Thai law into this, right? You can bring Article 48, Paragraph 2 and Paragraph 3, right? So this is the general rule. This is the general rule. Of course, we need to also bring up Article 79, which is corrections of errors in text or in certified copies of treaties. Now, this is where we have to explain the situation in Pravihan. And the situation is clear. Annex 1 map. So what is the error that the Thai lawyers were bringing up to the ICJ at the time? Right? So they tried to argue, this is where you need to apply the law, by the way. Firstly, you'll need to apply, okay, is it the Annex 1 map a treaty? Spoiler alert, the court says, yes, it's a treaty. Like I said again, it is an international agreement. In that case, it was concluded by Siam and France with consent, right? In written form, because it's literally a map, it's written. Governed under international law, whether embodied in a single instrument or 2 or more related instruments, and whatever its particular designation. So the ICJ concluded that it's a treaty. Now, the Thai lawyers at the time argued that Annex 1 map should not be considered a treaty because the map is wrong. It is an error. And like I said, we go back to the error under Article 48 that, hey, it's an error, therefore it's void, or invalidating its consent, basically. So they don't want to be bound by the treaty. However, at the end of the day, you're going to have to explain the situation surrounding it, and then finally explain why the court accepts the map. Spoiler alert, it is Estoppel. So that's all the way from the beginning, right? The general principle of law. Essentially, what happened in that case was that Thailand never protested about the errors of the map, nor does it protest about the occupation of Pravihan. And this is where you have to explain the principle of Estoppel, which basically means that if you inserted something in the facts, right? You said something in the past and you asserted it, then you cannot say the exact opposite thing. In this case, since Thailand never protested about the errors of the map, nor does it protest about the occupation, it is considered as an acceptance. And therefore, they can never raise the claim up to the court again, which would mean that, therefore, Thailand accepted the treaty, making it a binding treaty. So that is how you relate the principles of errors to treaties and Pravihan, right? And this is how you answer the question. Essentially, the main theme of both of these questions are not necessarily about the right or wrong questions, right? They're not really about like strict Iraq คำถามตุ๊กตาใช่ไหมครับ but it's more about explaining your understanding of public international law. So the case here is that you're going to have to read a lot. Well, that is it. So if anyone has any questions about it, CSP questions and answers on LB290 and ask a bunch of more questions there, because I'm sure there's going to be other principles that the professor might test us on. It might not be errors, right? It might be something else, and it should be something else potentially. So I'll see you guys, and good luck with the exam, everyone.